If someone on an F1 visa files an EB-5 petition along with concurrent AOS, advance parole, etc., when can they travel outside the United States? Rohit, I'll come to you for that.
Sure. If they're on an F1, super important to remember, you cannot, under any circumstances, leave after you've applied for an advance parole without the advance parole in your hand. Make sure that advance parole has your photograph and your name on it. And I don't mean it as in jest, because we've seen different people's photographs and different genders than the person who's supposed to get it. And it's a headache to try and get it remedied. And that's why I see Brandon and Nirel smiling. We've all, well, I can't do that, but they've certainly tried to tear their hair out in frustration. But the bottom line is that's super important. If you leave without getting the advance parole, you have automatically abandoned your adjustment of status. And then if you come back using an F1, you've got other issues to deal with as well. Just had a long conversation with a client yesterday where they want the child to attend back home for a religious function, and come what may, they've said, we will abandon the adjustment of status and let the child come back on an F1. And I basically told them they're going to sign off a disclaimer and a waiver, understanding that they've been advised against doing it and they could end up complicating his life. The only advantage in that case is he's not born in India. So he might fall under the rest of the world quota and comes back on an F1 and then files a new AOS. But absolute no to do it. Please follow your attorney's guidance when you filed your adjustment of status. Of course, your attorney will also discuss what you need to comply with before you file the adjustment of status. And I think that's the subject of many a discussion and many a difference of opinion. But certainly after you filed your adjustment of status, if you're on an F1, do not leave. If you're on an H or an L, and I think that issue comes up, you have a dual intent, but you have to understand that while you do not abandon your adjustment of status, the immigration will almost 100% deny your advance parole, which means you're going to come back, file all over again, and start play that game again.
I can't stress enough how much people should contact their attorney when they think about a vacation. I mean, I recently had a client who left the country in F1 while the adjustment was pending because his cousin said it was okay to do so. And I'm like, this is absolutely insane.
His cousin said that?
His cousin said, yeah, it's okay for you to travel. And I found out afterwards when he was abroad that he had done so. And so your first point of contact, whenever you're thinking about a vacation, doesn't matter what status you're in, even if you're an APEAD and you can travel, always contact your attorney first.
And I should stress, it's not just F1s that have this advanced parole and on the return 90-day issue. It's TNs, it's E1s, it's E2s, O1s as well. Basically, every B1, B2. Basically, it's everyone with the exception of H1B and H1B, H4, L1A, L1B, L2 individuals have this issue. And yeah, I just dealt with it too. I had someone on an E2 who didn't even tell me. They just went and traveled, even though I told them not to. And guess what? When the notice of intent to deny for the 485 showed up in our office, and like, oh yeah, here's all the times your client like left and re-entered on an E2, and there's no way to cure it. There's no way to cure it except to refile, which that isn't pay all the filing fees again. But then, knowing that USCIS could be like, wait a minute, your person, entered on F1 or TN after they filed EB-5 and file adjustment. So, and try to hit them with retroactive entry fraud. And just,
yeah.
And you've also possibly now got slammed with the possibility of unauthorized employment.
Yeah, it's true as well. Yes.
You've just complicated life in so many different ways that it was not worth listening to your cousin. Definitely not.
Your cousin's great, but yeah, call Nero before you call your cousin next time.
How is it different for, Brandon, this is to you, how is it different for H1B and L1A visa holders when they file for adjustment of status, etc.? Can they travel overseas without abandoning it?
That's correct. Well, they'll probably have their advance parole denied for abandonment if they travel while it's pending. The adjustment of status will remain, and what differentiates it is H1Bs, H's and L's have what's known as dual intent, i.e., they can be on a temporary non-immigrant work visa. yet still pursue permanent residence without violating the terms and conditions of their underlying non-immigrant visa. H's and L's are the only visa categories that have explicit dual intent. So yeah, so someone on an H or an L can file for EB-5 adjustment of status, leave the U.S., not be considered to have abandoned the adjustment of status, and re-enter under a valid H or L visa, no problem. However, now that we have, I used to tell H-1Bs, the advance parole, it's a waste of money, $630, and it takes, 6, 8, 9, 12 months. So if you travel after 5 months, you abandon and have to refile. So maybe save the money and don't do it. You can always file later. However, now with the Trump administration stunt from last week, now I've kind of changed that to say, first of all, don't travel on your H if you don't have to. And right. Let me stress, don't travel on your H if you don't have to. But now spend the $630 per person and get the advance parole and try to wait until that's approved before you depart the United States.
So I guess the difference is if you are on a non-immigrant visa without a dual intent, such as B1, B2, travel visa, or a student visa, you leave the country without advance parole, also known as travel document. You abandon your entire adjustment of status process.
That is correct.
Whereas if you're on H1 or L1 dual intent visas, you don't abandon your adjustment of status, only your travel document.
That is correct.
That's an important differentiator. With that, I would also like to ask you about the 90-day cool-off requirement, the difference between, again, dual intent and F1 or visitor visa. Is there a difference, or the cool-off period applies to both?
Yeah, so I think, as we've talked about, you can have a dual intent visa like the H or L, where you can have the non-immigrant intent to temporarily work in the US and the dual intent to pursue an immigrant visa. There you can enter on an H-1B, and the next day you can apply for an immigrant visa, like an adjustment of status, not a problem. With these other visas, the Bs, the Fs, the Es, basically anything outside the H or L, those aren't dual intent. So first of all, you can't come into the US for the sole purpose of applying for a green card. But, of course, intent can obviously change depending on what you're here to do, what your future plans are, et cetera, et cetera. Now, if you fall within 90 days, and I think the FAM is actually 60 days, but I think it's 90 days, a little bit more the conservative view. If you fall within that time, USCIS can come back to you and ask you to prove that you had the appropriate intent when you entered the US on your non-immigrant visa. Show us that you came in on that visa and that you were complying with the activities outlined by that particular visa and that you didn't have an immigrant intent. After 90 days, you're not really running into that sort of issue.
Rohit, Brandon, do you have any thoughts on this topic?
No, I just think, my gut is that it's better to take the safer option as opposed to having to worry about explaining your intent, which can be questioned several years after you had the intent change, and now convince an immigration officer that was my true intent when I came in. It's going to depend so much on facts and circumstances. And I'll give you a simple example where it can really come back to bite you. Let's say the family comes in and they've come in husband, wife, and young kids. Within 15 days, they've come in at the end of August. And you know what? Middle of September, school started. The kids were enrolled in school. Now you're going to try and convince an immigration officer 90 days later that you had no intent but to just come and travel the U.S. and be a visitor. That's going to be a real stretch. None of us over here would be inclined to buy it. And I don't see an immigration officer who is now charged with probably more deportation than favorable adjudication is going to give you the benefit of doubt. So maybe it was an extreme example, but I don't think it's unheard of. And I don't think it's that rare either. So you need to be really careful and, again, consult with your attorney, talk to them about it, make sure that you can be protected in the future, and then file the application.